I'd like to welcome everyone again and introduce Doug Murray and Eric Slutsky to make our presentation today.
Good afternoon, everyone. My name is Doug Murray. I am a member at Ehrenberg Golgen here in Chicago. I'm a corporate transactional lawyer, been practicing for 20 years, and my areas of focus are mergers and acquisitions, company reorganizations, venture capital investment, and complex shareholder agreements and operating agreements, partnership agreements to the extent necessary. I'd like to introduce my colleague, also here at Ehrenberg Golgen, Eric Slutsky. Eric?
Hey, everyone. I'm also a corporate attorney. I've been practicing for 5 years, focusing on mergers and acquisitions, private equity, venture capital, and general counsel work for various businesses.
Okay. At this point, I'm going to share my screen, so give me just a second to make sure it goes, and then we'll get into our spiel here. Sure. Okay. Can everybody see the presentation okay? Great. Thumbs up? Okay, great. So this presentation regarding shareholder agreements, operating agreements, partnership agreements is intended to be a primer. For anyone who practices in this area, as you may know, you can go a mile deep on kind of any one of these items, and there's quite a bit of variability. A lot of these are negotiated. A lot depend on the relative bargaining power of the parties coming into the deal and the kind of deal. It also depend on ownership. So do we have a closely held family company, or do we have, say, professional money coming into a new tech company? So I want to kind of touch the big things we want to talk about here. We're going to give you some background concepts, including comparison of entities, the objective of shareholder agreements, transfer restrictions, which are an important component of shareholder agreements, how they address some ways in which they address management, the voting aspect of shareholder agreements. We use the term voting agreements here because that's what's used in the Business Corporation Act, but essentially voting provisions are in the shareholder agreement or in one of the shareholder agreements of the company. We're going to briefly discuss dispute resolution and deadlock, and then also economic terms, really relating to allocations and distributions. A couple general background matters relating to this presentation. First, we're talking about private companies, not public companies. And in our case, we're really in the area of 1 to 200 owners. That's typically what we see, probably closer from 1 to 100. Again, this is a primer. Our explanations and examples are not exhaustive. There's a lot of variation. And again, the agreements are heavily negotiated. Just a note on terminology. Just because we have a presentation here, we're going to use kind of corporate terminology. So shareholder agreement, shares, shareholders, things of that nature. A lot of these concepts translate or are applicable for limited liability companies and partnerships as well. We are not addressing equity incentive awards. That's kind of, it's very much related, but we're kind of treating it as its own animal, especially a separate animal, especially in respect of this being a primer regarding shareholder agreements. Some of the kind of high-level objectives of shareholder agreements, right? Efficient and predictable management, protection of the company, and often its management, depending on the situation. An important one is keeping shares out of the hands of strangers. And this sometimes involves succession planning, especially in a family situation, or when we're looking at transfer restrictions relating to debt, dispute resolution. We're using the term shareholder agreement, operating agreement, and partnership agreement. those are the terms used in the Illinois business and the Illinois acts governing those kinds of entities. But these have a lot of different names and can come up in a lot of different contexts. So for corporations, sometimes you'll see shareholder agreement or stockholders agreement. A very popular one is buy-sell, especially in very closely held companies. And that used to be the term that was generally used when I started practicing about 20 years ago. Sometimes it's a stock restriction agreement. There are other names. And then if in some situations, especially if you have like Series A venture capital investment, the provisions are spread over a number of agreements. So you can have some of the provisions, possibly in the bylaws. You may have some in an investor right agreement. There could be a separate voting agreement. There'll be a right of first refusal and co-sale agreement. Sometimes a management rights agreement, and sometimes others. For LLCs, typically you're looking at an operating agreement or limited liability company agreement. Usually depends on what the what the LLC statute of the state calls it. In Illinois, it's operating agreement. In Delaware, it's a LLC agreement. Partnerships and limited partnerships, typically called a partnership agreement or limited partnership agreement. Just for the purposes of this presentation, we will not be getting into limited partnerships. The partnerships we're talking about are general partnerships. Eric and I create a business. We both have, we're both general partners or partners in the entity. Limited partnership, right? You have to have one general partner and one limited partner. Typically, the general partner has management rights. Typically, the limited partner does not. And a limited partnership is a statutory creature. A general partnership can be created just by operation of law when two people operate a business for profit. All right. Wanted to give a quick primer on the corps, LLCs, and partnerships, and some common features of each. Eric, I hand it over to you.
Thanks, Doug. So the three main entity types that we'll be discussing: corporations, LLCs, and partnerships. So for owners, corporations have shareholders, LLCs have members, and partnerships have partners. When it comes to management flexibility, corporations are the most rigid. They must have a board of directors and officers. LLCs and partnerships, on the other hand, are much more flexible. You can structure management however you like through the governing agreement. The transferability of interest is another key difference. Corporate shares are generally freely transferable unless restricted, which we'll get to in a later slide. But in LLCs and partnerships, transfers are usually limited to economic rights only. Voting and management rights typically stay put unless everyone consents. All the members are consent. The tax treatment, corporations default to C Corp status. So that means double taxation where the company pays income tax on its profits. And then shareholders pay tax again when those profits are distributed as dividends. Corporations can elect S Corp status for pass-through treatment if they qualify. LLCs and partnerships are naturally pass-through entities by default. LLCs can elect to be S Corp or C Corp status if that makes sense to the company. So the trade-off is pretty clear. Corporations offer structure and predictability. LLCs and partnerships offer flexibility and more favorable tax treatment.
Okay, so let's kind of set the stage for especially the transfer restrictions, because that takes up a lot of shareholder agreements and operating agreements. As Eric mentioned before, in corporation, the default is that shares are freely transferable, and in general, you cannot have unreasonable restrictions on transfers. In LLCs and partnerships, as Eric said, transferability is limited. An interest can be transferred but the transferee receives only a distributional or economic interest unless admitted as a member or a partner. Another general concept: courts typically respect reasonable transfer restrictions. They're considered to move with the interest, and that's important. There's also an interplay with an entity's governing statute. Shareholder agreements are relatively limited, and this is more general, in what they can do. Typically, the corporate statute is going to govern when you have an LLC or a partnership. The LLC Act or Partnership Act will provide default rules, and the intent is that most of those can be modified or abrogated by an LLC, an operating agreement, or a partnership agreement. One other point is that your shareholder agreement, LLC agreement, partnership agreement generally cannot contravene or conflict with the company's organic documents. So, for example, if your articles of incorporation say there are 3 directors, a shareholder agreement can't come in and modify that. You would have to either amend. You would have to go back and amend the articles of incorporation. And that's the same for a lot of other kind of default provisions in the corporate code. They often need to be modified through modifying the articles of incorporation or charter. The way that you typically see in a shareholder agreement, the way that you typically see the structure of transfer restrictions. First, you're going to see absolutely prohibited transfers. And then it moves to transfers are prohibited unless the board approves them, unless they're specifically permitted under the shareholder. So examples of absolutely prohibited absolutely prohibited transfers. Transfers that would be in violation of law. So, for example, if it would somehow violate a transfer would somehow violate a securities law, whether federal or blue sky, it's prohibited. And what you'll typically see is that the shareholder agreement just say they're void ab initio. Sometimes you'll have absolute prohibitions on transfers that would cause, say, an undesirable effect under applicable law. So, for example, if the company is an S corporation, which is a tax classification, has very strict rules on who can and can't own shares of an S corporation. And the restriction would say you can't transfer these shares to anyone who's not an eligible S corporation shareholder. If you do, that transfer is void. And then other kind of related absolute transfers are transfers that would kind of move the company, if you will, into an undesirable area. So examples is, would you be considered an investment company under the Investment Company Act of 1940? If you had a transfer where the company's assets would be considered plan assets and subject to ERISA, that would be prohibited as well. Sometimes there's an absolute transfer as to certain kinds of parties. You don't see this all that often, but sometimes, like, you can't transfer to a competitor, things of that nature. And then prohibited transfers then kind of moderates a bit, and it says a transfer is prohibited if it's not approved by the board and not specifically authorized by or permitted by other parts of the shareholder agreement. Okay, well, again, permitted transfers means that you don't necessarily, a way to look at permitted transfers is you don't necessarily need the board's consent to do them. Sometimes there's a permitted transferee, and those are persons to whom you can transfer your shares. Often they're going to be related parties. So something like an affiliate, something like an estate planning vehicle or a trust, those are often permitted and don't require the board's consent. They often require notice, but not necessarily the board's consent. Sometimes permitted transfers are transferred upon a triggering event, which we'll talk about several of those examples in just a minute. And I think a point that's important here is there's a lot of, when we start to talk about these transfer restrictions, there's a lot of variation. We're giving you kind of the black letter or a basic idea of what they are. You can go, again, a mile deep on a lot of these. So, Eric, I think you're taking back over.
Sure.
And the first transfer restriction we're going to talk about is a right of first refusal in the face of a bona fide third-party share sale.
So this is the ROFR, right of first refusal, is one of the more common transfer restrictions you'll see. The trigger here is when a shareholder receives a bona fide third-party offer for their shares. Before that sale can go through, the company and sometimes the other shareholders have the first opportunity to step in and buy those shares. So the rule's pretty simple. It's, the insiders can purchase on the same price and terms as the outside buyer. That way, the selling shareholder still gets the benefit of their deal, but ownership stays in familiar hands. For the mechanics, the selling shareholder typically provides notice of this outside offer, and then the company or the other shareholders have an election window. Typically, we see 30 to 120 days to decide whether they want to exercise that right. In practice, ROFR is usually applied to transfers involving less than a majority of the company's stock. Once you get into a change of control situation, you often see drag-along rights take over instead, so that minority shareholders can be compelled to participate in that sale. We talk about drag-along in a later slide.
And Eric, if I may, just in the comments, when we talk about the election period that the other shareholders have, that's a variable that can often be manipulated. So if I'll give you an example. So we're the company and we're putting a shareholder agreement in place. We know we're going to have investment in the future, or other shareholders in the future. And let's say a lot of those shareholders might be employees or something to that effect, where we want to maintain management control, and we don't want shares getting out into the hands of strangers. We may push that election period. So instead of being on the shorter end, we may want that to be closer to 120 days to essentially set up a barrier or hurdle, roadblock, or snare, whatever you want to call it, to someone selling their shares to a third party, especially in a corporation. Back to you.
I think we could go to the next slide. So now we're going to look at involuntary transfers. So here's, situations where shares change hands, not because an owner chooses to sell, but because the law or outside event forces it. So examples include a shareholder going through bankruptcy or an assignment for the benefit of creditors. Without protections, those shares can land in the hands of an outsider the other owners never intended to deal with. So that's why these provisions give the company and other shareholders the option to step in and purchase those shares. The price is often based on the fair market value, but it can vary. Sometimes it's by formula, by an agreement, by a third-party appraisal to resolve disputes, but that's usually buried in the agreement. Mechanically, the transferring shareholder or their representative must give notice, which starts the clock on the company's right to act. So the exercise period is 30 to 60 days. So the key point here is that involuntary transfer provisions are designed to keep ownership from ending up with potentially adverse parties and ensure the control of the company stays within the intended group.
And Eric, if I may, with respect to some additional comments, in these kind of situations, you're sometimes looking at a potentially adverse transferee. That is the shareholder who was the subject of the involuntary transfer may be transferring to a creditor. If that creditor gets a hold of those shares, that creditor is going to want to turn those usually illiquid shares into cash. So they may take action as a shareholder, say under the Corporate Act or the LLC Act, to potentially dissolve the company. So we want to keep that's the reason we want to keep. We especially want to keep shares out of their hands. The other point is this exists in the context often of a bankruptcy or an assignment for the benefit of creditors. So when we're looking at setting the pricing, we often want to get some idea of what the law says on what that share price needs to be. That's just a point to be careful on, is if you're setting the share price, let's say at book value, and book value doesn't bear a reasonable resemblance to fair market value, you may have an issue. That restriction might be deemed to be invalid. So that's something you'd want to look at when you're drafting this provision.
Okay, so drag along rights. So these come into play. So these come into play when the majority of shareholders want to sell the company. Without them, a minority shareholder could hold out and block the deal, which is a nightmare for buyers that want to acquire 100% of the company. So the idea is, if the majority approves the sale, the minority shareholders are required to go along, either by selling their shares on the same terms or by approving the transaction. This makes the company much more marketable, since a buyer knows they can get a clean exit. The price is usually whatever the majority is getting, though the specific terms can depend on the agreement, just like many of these other rights that we've talked about. The notice periods are often short, usually long enough just to give the minority like a formal notice and time to sign the paperwork. Sometimes we see the drag along called bring along rights or approved sale provisions. They often include protections for minority shareholders, such as limiting their liability or ensuring they get the same form of consideration as the majority. So I think the key takeaway is that drag along rights, they balance efficiency and fairness. They keep a minority shareholder from holding a deal hostage, essentially, while still giving them the benefit of the bargain struck by the majority.
And if I may, just a few comments here. This is one of those transfer restrictions where we're giving a very basic description for purposes of a primer. The shareholders who can be the dragging shareholders can vary quite a bit. Sometimes it's a certain percentage of preferred stock. An LLC, sometimes it's a managing partner or a manager, or it could be a specified percentage of shares. So the right holders can vary. The price, the way you see it, the way you'll see this often in a form document, is that the price is basically the same as what the other shareholders are paying on a pro rata basis. That when preferred stock comes in, especially, that can change, because what you'll often see is if there's an exit and you have a couple different series of preferred stock, and then you have common, especially if you have like participating preferred or something, the prices for each series that they would get in an exit would vary. So oftentimes you don't see that pro rata proportionate element. You'll see just an approved sale saying that if the dragging shareholders approve the approved sale, everybody has to follow it. What you may also see too, depending on how much power the minority has when the shareholder agreement is being drafted, or when the drag along is being drafted, is you may see the minority shareholders want minority protection rights. So these can be things like, we have to sign the purchase agreement in the exit transaction, but we don't have to make any indemnities save with respect to, say, fundamental representation. Our indemnification obligations are limited to our cash proceeds, and so forth. And sometimes you'll see this paired with a power of attorney. So the idea here is the drag is invoked. You can't get a hold of one shareholder, or one shareholder refuses to sign. After 5 days, the president of the company, or whoever is designated as the attorney in fact, then has the right to sign on their behalf under the POA. You have to be very careful about that, but it's a provision that you'll sometimes see in the shareholder agreement. Often that POA covers items other than just the drag along. Usually covers most of the transfer restrictions where there's some kind of call right, but I'm just putting it out there. Okay, Eric, let's move on.
Okay, so then we can go to 13. So transfer restriction. So the tag along. So if the drag along that we just discussed more so protects the majority, the tag along protects the minority more so. So the trigger is when the majority shareholders intend to sell their shares. In a situation like that, the minority shareholders get the option to join in or quote unquote tag along on the same terms. So the right ensures that if the controlling shareholders sell, the minority can sell their shares too at the same price and on the same conditions. Usually there's a 30 to 60 day window for the minority to decide whether they want to participate. And tag along rights they're not always included. I don't always see them, but they're an important safeguard. They prevent minority owners from being left behind or having the controlling interest sold out from under them. They're also often invoked when drag along rights aren't exercised. So while drag along makes the company or a company easier to sell, tag along, kind of ensures fairness by letting the minority come along for the deal.
And a point there is that if any of you represent clients that may be wishing to seek professional money, especially if they're at an early stage and they're maybe looking for eventual venture capital investment, other kind of investment like that. Actually, let's table that conversation till preemptive rights. All right, back to you, Eric.
I think you got this one on the next.
Oh, okay. So a very common transfer restriction relates to termination of employees or termination of service. So the idea here is, let's say you've issued a stock to someone who is a service provider to you or an employee to you. They leave the company, or you let them go, whether it's a good situation or a bad situation. And let's say actually it's acrimonious. You don't want them to have shares or rights in your company. So the idea is they terminate their service and you essentially buy them out, get the shares back. Can work a number of ways, and it depends on how the situation is set up, how the employee came in. The way it typically works for most employees is that the company has a call right, essentially, and they would buy the employee out at a specified price. Sometimes in some situations, especially where you've brought someone in to say run your company early, they have a put right. Doesn't happen all that often, but sometimes they'll have a put right, and they can be bought out at a specified price. How is that price determined? That price is often determined based on putting the way they left the company or the way they were terminated into a good leaver or bad leaver situation. I'm oversimplifying here, but that's the basic idea. If we have someone who left in a good leaver situation, so for example, if they were terminated without cause, oftentimes you'll buy them for fair market value or a respectively higher price. If they're a bad leaver, this is often a for-cause termination. Sometimes it's resignation, a voluntary resignation. You would buy them out at a lower price. This is often considered to be reasonable because many times employees who come in don't pay that much for their stock. It's usually provided to them for services. So it's often not considered to be unreasonable. Obviously, you have to check that when you draft your provisions. This is often also often handled or addressed if shares are issued under or options are issued under an equity incentive plan. Oftentimes, the equity incentive plan itself will have those kinds of buyout provisions, the exercise of buyout provisions. And typically the period, let's say it's a call right, the period is often can be right away for cause a lot of times. You were a bad boy and we're taking your shares back. To 2 years is kind of on the outside. Often you see it in that 1 year, 6 month or 1 year period. But sometimes if you have an S corporation, so you have a family corporation, you want to give the shareholders sometimes to make different elections. That's especially true in a death scenario where you might make an election to have a qualified S corp trust. Okay, move on here. Is this me?
Sure is.
Death can get complicated. And there's a lot of variability, and it really depends on ownership, respective bargaining power at the time that the provisions are entered into. The right holders there's usually two right holders involved. One is the decedent's estate, could be as estate planning vehicle, could be trust, and then also the companies and sometimes the other shareholders. And again, this really depends on what kind of company it is, what the ownership is. So, for example, if we have a closely held family-owned company, we want those shares to stay in the family. So sometimes there's a mandatory, or sometimes the shares just transfer to family members. Sometimes it transfers to a trust. Sometimes the shares are already in trust or in an entity estate planning vehicle, and no transfer is necessary. Sometimes and again, this depends on whether it's family or not, or what the ownership looks like. Sometimes the company has a call option, and they can buy you out. And sometimes the decedent's estate has a put right. And this is where if it's an S corp and trust, sometimes there's a 2-year period there, so they can make a USST election. Mechanically, usually the decedent's estate gives notice. Sometimes other notices are given by the company if there's some kind of an option by the other stockholders. Notice periods for something like this or election periods go anywhere from 3 months, usually to about 2 years. Then you'd look at the source of funding. How is the company going to pay for it? When we're talking about a regular employee, sometimes you just pay it in full. Sometimes it's a note, and that note can be extended. That note can be anywhere from 1 to 7 years, somewhere in there. Sometimes it's funded by insurance, especially in a family company situation. There could be succession planning issues at play. This can also fall under termination of employment. So if you, let's say you just have a regular employee, death actually wouldn't be a unique event. It would be a termination of employment, probably as a good leaver, and then the employment transfer restrictions or buyout provisions would kick in. Okay. Are you disability?
Yeah, I'll take it.
Okay.
So when we talk about disability or incompetence, the issue is what happens if an owner can't continue participating in the business. This comes up most often when the shareholder is also an employee or a service provider, and companies handle this a few different ways. Sometimes, sometimes there's a buyout right for the company or other shareholders, and other times the shares convert to non-voting stock, as an example. So the person keeps the economic right, but isn't involved in the governance anymore. The pricing is usually based on the fair market value, but because disputes are common, many agreements include an appraisal process as a fallback. I've seen that. And the critical detail is how the agreement actually defines disability. You know, is it tied to time away from work? You know, a medical condition, something else. The definition of disability would be defined in the underlying agreement, the shareholder agreement. And that definition often drives how these provisions work in practice.
Right. Sometimes it's tied to the long-term disability definition. Sometimes you need a doctor's note.
Right.
Divorce. So this is a situation where you don't want the divorced spouse to have ownership. This is something that when you look at a lot of form shareholder agreements, they often don't address this very well. They'll put this into involuntary transfers, and that's sometimes insufficient because you're dealing with a divorce court proceeding. So we often have a transfer restriction specifically for divorce in our shareholder agreements, and we often take an approach, a multi-tiered approach. So the idea is there's a divorce. Couple steps. Step one is, and also it's important if we're dealing with a community property state or not. But the basic idea is the shares are in the divorce decree will be allocated to the separating shareholders. If that doesn't happen, the separating shareholder has an option, can purchase the shares from the divorced spouse. And if that doesn't work, then sometimes the company and or the shareholders will also have a call right. So the idea is we're trying to use a multi-tiered approach to keeping the shares out of the other spouse's hands. And this may be especially important because there's often quite a bit of acrimony involved with the divorce situation. The price is usually fair market value, and that's because we want to make sure that it's fair market value for purposes of the divorce proceeding. And the way it often works is it can be by agreement of the purchaser and the divorced spouse, with a backstop to an appraisal to make sure that if we're going back to the court, yes, we agreed this is the fair market value, or if no, we didn't, and an independent third party appraiser said this is fair market value. Okay, and again, with respect to comments, need to look at the states that are at play or may be at play, and oftentimes you assume that a community property state may come into play. That is where the husband and wife, in the case of traditional marriage, the husband and wife have an ownership interest in that in the stock. It isn't like it's titled in one and the other one doesn't have an ownership interest. And we often start kind of from that premise. And when we talk about the divorce, we're often addressing not just marriage, but domestic partnership, civil union, or any kind of similar relationship. Is this you or me?
I'll take it.
Okay.
Preemptive rights come into play when the company issues new securities. The concern here is dilution, existing shareholders losing ownership percentage if new investors buy in. These rights, they let the specified shareholders buy their pro rata share of the new issuance before outsiders, essentially giving them the first shot to maintain their stake in the company. The price is the same as what's offered in the financing, and the company usually provides notice with a short election window to decide. Not every issuance is covered. Exceptions, include stock options or share dividends, and sometimes, or I guess some states even provide default preemptive rights unless waived. In venture capital settings, these rights are sometimes narrowed or tied to pay-to-play rules, where only continuing investors keep that protection. So I think the takeaway with preemptive rights is that they protect shareholders from dilution, but they can also complicate fundraising and negotiations if every investor insists on participating.
And the other takeaway is some states have a default preemptive rights provision in the statute that can only be abrogated by an opposing provision in the Articles of Incorporation. So you need to check. So for example, Illinois has default preemptive rights. So when you draft your Articles of Incorporation, you got to make sure you get something in there saying shareholders don't have preemptive rights. So we'll talk about management. These last couple of slides we're going to go through a little more quickly. They're a little more conceptual. Go ahead, Eric. It's you.
Yeah, we're jumping around a lot, but there's not too much more. When we think about management structures, the level of flexibility really depends on the entity type. For corporations, and I kind of discussed this earlier, management is fairly rigid. By statute, you have to have a board of directors and officers. A shareholder agreement might tweak how directors are elected or even address certain officer roles, but at the end of the day, the structure is fixed. LLCs, on the other hand, are far more flexible. They can be member managed, manager managed, and the operating agreement usually sets those rules. If the agreement is silent, the default is that all members manage on a per capita basis. That flexibility is one of the big reasons LLCs are popular. Partnerships fall somewhere in between. The default rule is that all partners share equally in management, but the partnership agreement usually sets out how decisions are made, whether it's by a managing partner, a management committee, or simply by a majority. That's all I got for this one. Okay, I think this is back to you, Doug.
So that has to do with management and maybe something a little closer to board level decisions. This is actually voting rights. So in a corporation, the voting rights of shares are established in the Articles of Incorporation. Those voting rights follow the shares. They can't change. You can swap out or exchange shares, but those shares have the voting rights that they have. Also, the corporate statutes usually provide for minimum approval requirements for certain kinds of major transactions. So if you're going to sell the company, if you're going to amend the charter for more important things, if you're going to dissolve the company. So by operation of the Corporate Act, you need to have a certain percentage of the votes. So kind of similar to a drag along. It's essentially kind of how it works. If a specified percentage of or specified shareholders approve the act, everyone agrees that they're going to vote in favor of the action. That's essentially how a voting agreement works. And it can be for a number of things. Again, it could be changing bylaws, but usually it's amending Articles of Incorporation. It's a sale of the company to dissolution. Should say LLC. In a LLC or partnership, as Eric mentioned, you have default rules, which is usually per capita. You can change those in the operating a partnership agreement. So you can vote based on your percentage ownership interests, or you assign it to a manager, or you say one person will be the general partner or the managing. That's the basic idea. And again, with respect to voting agreements, what kinds of things are often in voting agreements, especially where you have, especially in a corporation, electing stockholders. Electing directors. So often the corporate statute will say you need a minimum number of votes to elect a director, but maybe the articles say that a particular series or class of preferred stock can designate a director. The voting agreement will say, okay, Class A can designate a director to the board, and when they do, everyone else has to vote in favor of that director. Similarly, exit events such as a sale of the business, asset sale, that's the drag along. Certain kind of charter amendments. Sometimes you want to preemptively, if you think you might be reorganizing your company or converting it, especially if it's an LLC, or if you have a state law corporation that's taxed as an S corporation, you know that, and you think you're going to be bought in a private equity sale or a private equity purchase, a PE sponsor back, they often require F reorganizations. You'd want everybody to preemptively agree to that. And what else? And tax matters. So the idea here is the IRS rules often require either all the shareholders or a specified percentage of shareholders agree to some kind of a tax election, or to appointing a partnership representative, things of that nature. You'd want it in your agreement that once the specified people or specified owners approve it, everyone else will also approve it. Okay. Dispute resolution. Is this me or you? That's you.
I've got this on the next one. So dispute resolution and deadlock provisions. So these are, I think these are some of the most important and sometimes overlooked parts of shareholder and operating agreements. First, agreements usually specify the form or venue for disputes. So that might mean agreeing in advance which court will hear disputes, or sometimes pushing parties towards an alternative dispute resolution like a mediation or arbitration. Having that clarity up front avoids fights later down the road about where and how disputes get resolved. Deadlock provisions kick in when owners or directors can't agree on fundamental issues, things like whether to sell the company, change the business plan, raise capital, are some examples. Without a clear process, deadlock can paralyze a business, honestly. The statutes, whether you're in a corporation, LLC, or partnership, do provide judicial remedies, but those range from injunctions, damages, all the way to dissolution of the company. Because that's such a drastic outcome, it's usually better to build in contractual solutions that give the parties a roadmap for working through major disputes. That's all I got for this one. So some examples of deadlock mechanisms. So when owners can't resolve the deadlock, the agreement may provide specific mechanisms for breaking the tie. And these fall into two broad categories, structural and procedural. Structural mechanisms change the governance itself. You might give a designated person, say a chairman or even an outside third party, the final say. Another option is to add an independent director to the board. Some agreements go further and build in automatic triggers like a forced buyout or even dissolution of the company if the deadlock continues. Procedural mechanisms are more about process. They often start with negotiation and then escalate to mediation or arbitration. It's, a more aggressive version is bidding procedures. So some of the examples we added are quote unquote Russian roulette. Shareholder A names a price and shareholder B must either buy A's shares at that price or sell his shares to A at that price. Another example, quote unquote, the Texas shootout. That's where both sides submit a sealed bid and the higher bidder buys out the other. Each of these approaches has their pros and cons. Structural solutions can provide clarity, but can feel harsh. And bidding mechanisms can resolve a deadline quickly, but risk disadvantaging the less capitalized party. So, there's no one size fits all answer. It depends on the group.
All right, and when you see these kind of bidding procedures, a lot of times these are in something that's actually or close to a two-person company. It doesn't always work if you have kind of diluted ownership. But again, you need to look at the parties. You need to look at the complexity of the business. So, for example, if you designate an independent third party or an arbitrator, you have someone potentially deciding on the fate of your business who doesn't know anything about your business, who doesn't do what you do. And if you're in a very specific area, niche area, that person may not be able to understand the complexities of what's going on. It's the same issue you have in choosing an arbitrator. It's the same kind of idea. Okay. So economic terms, this is a primer. This is a very high level. So the focus for purposes of this presentation are allocations of income and profit and loss, and dividends or distributions, depending on if you're a corporation or a LLC or partnership. And when I say distribution, I mean a payment of the entity's assets to its owners on account of their ownership, right? So when we talk about allocations in a corporation, it's not driven by the corporate statute. It's typically driven by the tax code and accounting rules. The default dividends and distributions are usually addressed in the articles of incorporation. For LLCs and partnerships, allocations and distributions, again, are often in the partnership agreement or the operating agreement. When you look at default rules, and this gets to the more, first, if you don't want the default rules to apply, put the economic provisions in your articles, your LLC agreement, or your partnership agreement. When you look at the default rules, they may not get you where you want to be. So, for example, for a corporation, the default is that if your articles are silent, the default is that all stock is common stock and it's distributed pro rata based on ownership. So if you have preferred stock, you have people who are supposed to be getting paid first or second. The idea is you're going to have some kind of participating preferred or non-participating preferred, or whatever the variation is. If it's not in the articles, it's not going to happen. The default is common pro rata. For the LLC statutes, it says that interim distributions, that's distributions before the company's liquidated, are in equal shares. And then for liquidating distributions, they go according to you get your capital contributions are returned, and then you have equal shares. Those might not comport with the tax election you've made, so they might not line up with the partnership rules for allocations like under 704B or 704C. And for an S corporation, they may not work either, because for an S corporation, your governing documents have to have identical distribution and liquidation rights. For partnership statutes, and that was in Illinois, it varies by state. In Illinois, profit and loss is usually allocated equally among the partners. Then your distributions are based on your partnership accounts. These are somewhat similar to capital accounts, say under 704B or 704C. Those are sections of the Internal Revenue Code, but they might not match up. If you're 50-50, you're probably okay. But if you're not, then you're probably going to be allocating things improperly and in violation of partnership rules, allocation rules. So again, it's usually best to get your economic provisions into your governing documents. In the case of a corporation, it's the articles of incorporation. In the case of a LLC, it's your operating agreement. And in the case of a partnership, it's your partnership agreement. I hope that makes sense. And with that, I think we're finished with 5 minutes left. So at this point, I'm going to stop sharing.
I don't see any questions in the chat. Perhaps people need a moment to type something in.
And if you don't, we'll do this for 4 minutes.
Oh, why don't you start doing that? If something pops up, I will let you know.
I was born in Oak Lawn. It's a southwest suburb of Chicago.
All right, no questions at all? Okay, well, then.
Did you want me to speak? Did you want me to comment on a couple of the items?
Yeah, if you've got like 2 or 3 minutes to add to it, that would be great.
Okay, let's go back to preemptive rights. So a point to make here is that if you're looking to have, if you're looking to get venture capital investment, professional money to come in, venture capital investors, professional investors often don't like to see preemptive rights before they come in. And the reason is that typically your VC is going to value the company and they're going to buy in for a specified percentage of that company for a specified amount, 20%. They don't want a situation where they value the company, set a price, and then other shareholders have the opportunity to come in. They're either going to make those other shareholders waive it or they're going to take a pass. So I hope that makes sense. What else? And I do want to stress the importance of default rules. One other point that often comes up that I get all the time is, if I have a single member LLC, do I need to have an operating agreement? Okay, so often the general answer is not necessarily, because the default provisions are at play. But I always recommend that you do. From a cost perspective, it doesn't cost a lot to draft one of these. Typically, you take them off the shelf. First, you can provide indemnification and other protections that may not be available under the LLC Act. Second, you give a clear record of your ownership. So if somebody says, "Who owns this LLC?" you pull out your 3-page single member operating agreement and say, "I do," or "he does," or "she does," or "it does." Third, when we start talking about making tax elections, if you make an S election, that is, you make an election for the company to be treated as an S corporation for federal income tax purposes, and there's no operating agreement, you default to the governing provisions of the Act, which may not necessarily work. Probably doesn't matter. From the standpoint of an audit, we find that we often like to have provisions in place to say, no, allocations and distributions are going to be made in accordance with the one class of stock rule. No transfers to persons who aren't S corporation or S eligible shareholders. So that if, well, let's say you get audited later, you pull out a 3 or 4 page piece of paper and say, listen, we're really trying to respect the fact and protect the fact that we have an S corporation. And that got us to hour and 15 minutes, or it got us to 1:15.
Okay, thank you very much. It was a wonderful presentation with lots and lots of information. We are going to be sending the slides to everybody after the class, so you will be able to go back and look at it, because I know it was a lot to take in. And again, I want to thank Doug and Eric very much for this presentation. And I will be reporting the CLE credits. I know several people have asked about that after the last class. All the CLE credits for a particular month need to be reported by the 5th of the next month. So by October 5th, if you don't see your credits appear in your MCLE account, then shoot me an email and I will straighten that out for you.